Hi, this is Mike Benoit again. I'm going to do today. I'm going to talk about some more of the summary judgment process on my case, and this is where the Franchise Tax Board has replied to, and they replied in opposition to my motion for summary judgment against them. This is State of California Franchise Tax Board, and their reply is quite interesting. As you know, I referred to earlier the fact that the state of California in this IRS suit to foreclose on my home was listed as a defendant. So it's really kind of a twist of terms there, because they're actually somebody that's another party against me, because they want $30,000 or whatever to go along with the $144,000 that the IRS wants. So they file an answer to that, and their answer is quite interesting. Basically saying that there's no claims that can be adjudicated between Benoit and the Franchise Tax Board. Now, of course, one of the charges for the district court in one of these IRS foreclosures is that the district court actually evaluate the merits of all liens on the property. So they have to evaluate the merit here, and this is why the United States, or the IRS, actually named the state of California as a defendant, because they have a lien there. Well, but the state of California is trying to claim that a motion pursuant to Rule 56 of the Federal Rules of Civil Procedure is for the purposes of disposing a case or issues in a case between the plaintiff. And I'm not going to actually read that because it will just seem more confusing. But what they're trying to claim is that the Rule 56 for summary judgment is for an action against, like in this case, the IRS against me, and not them. So then they go on to say the court lacks jurisdiction to determine the amounts of taxes owed to the state of California in this matter. Now, they refer to in my motion that I deny owing state income taxes, and that I argue that taxes were never assessed. They say I allege that the statute of limitation has run, preventing the state of California from filing suit for tax liabilities. FTB did not file suit against Benoit. And of course, that wasn't my point. My point is, if I actually did owe taxes, then the statute of limitation had run out many years ago with the state. The feds, it's 10 years. The state is 4 years. So it wasn't about them filing any lawsuit. Now they're also saying that that the Franchise Tax Board was named as the defendant in the instant action along with Benoit. The Tax Injunction Act, 28 United States Code Section 1341, bars Benoit's claim for any relief. And then what they're saying there is that the Tax Injunction Act states that the district court shall not enjoin, suspend, or restrain the assessment, levy, or collection of any tax under state law where a plain and speedy, efficient remedy may be had in the course of such state. Well, that may seem gobbledygook to you, but in essence what the state is arguing is that the district court cannot enjoin the collection of any tax, which is a fallacious straw man argument, because I'm not asking the district court to enjoin, suspend, or restrain the assessment or levy or collection of any tax. I'm just asking within this case to grant summary judgment for me against the state, because they actually have no case in the fact that there's no assessment and there's no statute. They have run on the statute of limitation. And it's obvious they have no chance of any efficient remedy in the state court, because the statute of limitation has run. So they're basically saying that the United States District Court can't adjudicate the merits of their lien, and that's absolutely untrue. So they say when applicable, the Act divests federal courts of jurisdiction over actions against state revenue collection statutes. And of course, the state has no course, nothing left open to it to collect this, except if the government, the district court, decides not to judge the merits of their claim and just grant summary judgment to the government and allow and order sale of my house and proceeds to be paid to the IRS first, after the mortgage holder, and then the franchise tax board next, without judging the merits of the claim. And of course, that's what they're shooting for. They go on to say that the Supreme Court and the Ninth Circuit have ruled that California's administrative and judicial tax refund procedures provided plain and speedy and efficient remedy. This is even true in California. That's all nonsense. The Tax Injunction Act is construed broadly. It applies to actions for declaratory relief. So they're trying to state that this court has no jurisdiction to grant my motion, that this court divest the federal court of jurisdiction over the claims, that the Anti-Tax Injunction Act divests this court over my claims. So the franchise tax board that is asking the court to deny my motion. Now, the franchise tax board did not address the issues in their response. They're basically saying that the district court doesn't have jurisdiction, or that the district court would be violating the Anti-Injunction Tax Injunction Act, which is nothing could be further from the truth, because there's no taxes that the state could collect in this matter, because first, they didn't assess any taxes, and secondly, they didn't, the statute of limitation had already run out. Now, the state of California did not address those two key points, whether or not a tax was assessed. They never denied my statement or my claim that there was no tax assessed. And in my papers, I showed that there wasn't any. And nor did they deny that the statute of limitation had already run out. They're trying to hang their hat on the fact that the state cannot be denied or cut out of the game because of the Anti-Tax Injunction Act. And they were actually cut out of the game because their lien was invalid because of the statute of limitations. So that's the state on that. Now, I have another response over here that I want to cover in regards to the feds, where they responded to my summary judgment, or they actually, their response in opposition to my summary judgment motion. Let's see what they said here, because you don't want to hear all of this stuff. Basically, they're arguing that, no, I guess I have to cover this or it won't make any sense. But they're arguing against my motion for summary judgment. As you recall earlier, they had a motion for summary judgment. I opposed that. Now they're opposing my motion for summary judgment. And United States motion for summary judgment has demonstrated that Benoit had income during tax years 95 and 96. And then they falsely claimed that I also admitted the fact in my deposition that I had income. I did not. They're misstating my deposition here, and they don't have any proof that I had income. And then they say I made enough money from my business to pay my bills, so therefore I had to have income. Well, there was checks from the business that were written to me, but in those days I loaned the company money. I had loaned the company a lot of money, and the company had to pay me back on those loans by check. Now, because when the company first started out, I help fund the capital for the company to get it going. So they have copies of checks written to me, and they're trying to claim that that was income to me. They have no basis to claim it was income. They have no idea what those checks were for. So that isn't. That's an assumption, assuming that I had income there, and that's all they had to operate with. In an action to collect federal taxes, the United States bears the initial burden of proof, and that burden can be satisfied through the introduction of proof of tax assessment. Now, that's the part of my whole case here. They never produced any tax assessments. And if they had produced tax assessments, then this would all be a different matter. But they're acting like here in their opposition to me that they produced them, because they just state that what the federal courts have stated in that regard. So it's duplicity at its worst. Again, the United States bears the initial burden of proof. That burden can be satisfied through introduction of proof of tax assessment. They didn't produce any proof of tax assessment. So, and they state that those are entitled to a presumption of correctness if they produced them. Certificates of assessment and payments are routinely used to prove that assessments have in fact been made, and they quote a case on that. They're not proof. They're what they call presumptive proof, and these 4340s are used to help grant summary judgments, but they don't prove that the assessments have been made. And the presumptive proof is not proof of a valid assessment, but that's what they say here. They're just presumed true unless I can rebut them. And that's what this whole summary judgment process has been about. I've rebutted their presumption of truth on several issues. And so again, I'm just fighting to try to get a jury trial. I'm not really trying to win the case here. They're trying to get the judge to say, okay, Benoit, you lose. Actually, that's what he gets into doing a little bit later. In this case, certificate assessments and payments for the tax year at issue are attached. He attaches those. These computer certificates of assessment and payments, that's not actually what they're called either. They're not certificates of assessments and payments. I should get a copy out. Anyway, she's misstating what they are. So that makes it look like they're actual assessments, but they're not. I wonder if I got a copy of that real clear. Close here to clear. That's 4340, the actual name. Certificates. Don't have it, so we'll go on. The determination of assessments of Benoit's tax liabilities are further supported by Benoit's deposition responses. How would my responses have anything to do with assessments from the government? Benoit himself admits that he did, in fact, receive notice of the assessments made against him. No, I did not receive notice of the assessments made against me. I received all kinds of other documentations that were not, they were notices of deficiency. They were, we have changed your account, things like that. There were not notices of any assessment. I was asking for those for years. Then they go on, Benoit's rhetoric regarding the assessments made against him are without merit. None of these arguments have been recognized as legitimate, insulating individuals from federal income taxes. And again, part of my whole argument with them was, where's the assessments? Where's the tax? What code section imposed the tax? Was this a tax on my, life, my liberty, my property, some action I was engaged in? What's the nature of the tax? My argument was they have these penalties for late filing, and they admit that there was no filing. They had penalties for negligence. The record is full of evidence that I wasn't negligent in this matter whatsoever. So again, all these things to say, wait a minute, maybe this thing is not accurate. Let's have a trial here. And that's all my burden was, is to demonstrate that their Form 4340, which was issued in the year 2006, which was issued 8 years after the alleged assessments were supposed to have been made. So that they go on and they're saying, so let's get our summary judgment in favor of the government here. And let's see, I guess there's more here coming from them in the IRS. Response to Benoit's statement of facts. Claiming problem with my statement of facts or evidence. I'm not going to get into all of that because I guess if we did a 2, 3, 4 hour video and just went back and forth on this stuff, maybe all these briefs and motions or whatnot would probably take a few days to go over, and so people would really understand how it works and what's actually happening there. But again, the United States denies all my allegations. They weren't allegations; they were just statements of facts. So, again, summary judgment motions are supposed to be based on the idea that there's no disagreement on the facts, that the facts are not in disagreement. There's what they call no material issue in regarding the facts, no material issue of disagreement in regards to the facts. And we had a ton of them. And that's what summary judgment should be based on. So you go through all, if you want, the legally gobbledygook, and then you get, oh, here they are. You get this, well, actually, when I start reading the decision from the judge, you'll get a better idea of the gobbledygook and how he comes up with this decision. And so if we're a judge to grant a decision on a summary judgment motion, for a judge to grant that, he's going to sit down there and say, well, there's no disagreement on the facts. And that's what when I read his decision, you'll see that's the kind of nonsense he puts there. When if there's no disagreement, what have we been disagreeing over for 15 years? Why hasn't the IRS produced me any of the proof that I've asked for? And why is this fight for 15 years? So I did make a reply to these oppositions on my motion for summary judgment. My reply is against the IRS and the state. And I objected against the IRS's summary judgment response because they brought up new things that they were kind of like a third bite at the apple, and which is not okay. You're only supposed to address in the responses in opposition those things that were brought up, and not address a whole different set of things that just amounts to you adding on to your summary judgment motion. Now, the plaintiff's response, they put up a straw man argument. My grounds for summary judgment is the government is not assessed or properly assessed or produced assessment of taxes regarding the alleged liabilities that are the subject of this suit. I've not used the summary judgment place to argue that I did not have taxable income or wages or income of any kind. I'm arguing that they did not satisfy their requirements to grant their Form 4340 a presumption of accuracy, a presumption of being correct. So that presumption was rebutted. Now it's time to go to trial. They haven't. The plaintiff have not presented one shred of evidence to counter the evidence presented by me, and that no assessments actually exist for the liabilities. The plaintiff attempts to rely on its pleadings to save it from summary judgment in favor of the plaintiff, in favor of the defendant. Plaintiff argues that the defendant had income, wages, etc. for the years in question. She argues that the defendant paid his bills and makes several references to assessments and quite a bit more. All of this rhetoric is off point. Benoit does not feel he has to refute any of these assertions, even the mischaracterization of his deposition. Benoit will not address point-by-point plaintiff's straw man argument. The essence of defendant's summary judgment motion was elements as to whether or not the plaintiff can carry its burden at trial is whether or not taxes were actually assessed. And without assessments, there is no liability. Defendant has asked for summary judgment based on the fact that the government will not produce any essential element that they need to prevail at trial, and since an essential element is missing, there can be no genuine issue as to any material fact. And that's in the Celotex Corporation versus Catchat, 477 U.S. 317. The party moving for summary judgment bears initial burden of establishing the absence of a genuine issue of material fact. Since the plaintiff has not supplied any actual assessment of taxes on defendant Benoit over a 12-year period, no other conclusion can be made except they must not exist. Thus, an essential part of the plaintiff's burden is lacking. Without assessment, no genuine issue for trial. There is no debt without assessment. If there's no assessment, there's no liability. Without assessment, this case is lacking in essential elements for the plaintiff to carry its burden at trial. The Internal Revenue Code provides for a specific procedure for assessment. An assessment is administrative determination of tax liability. Court case. And until the assessment has been made, the tax is not found to be owing. The plaintiff has not produced any affidavits, depositions, answers to interrogatories, or admissions that will go to demonstrate the existence of the assessment. The plaintiff attempts to use presumptive proof of a valid assessment, which the courts have allowed only when there is no evidence to counter the presumption. We agreed with these, so we go on, and then I have a reply to the defendant, FTB. Actually, I discussed that with you already, so I'm not going to re-argue it. And the FTB trying to argue that the court doesn't have jurisdiction is ridiculous, because they're asking the court to settle the matter in their favor. So Benoit has proved to the court that an essential element assessments needed for either the plaintiff, the United States, or the defendant franchise tax board do not exist. There's no evidence to rebut the efficacy of defendant's arguments or evidence. Without tax assessment, there's no case, But again, keep in mind, I'm just trying to get a trial. So that's enough on this. I may have one more thing to come up with. Now that's enough there to show you this on summary judgment. Hey, let's have a trial. But there's a lot more stuff to this case that's coming up.